Linda, thank you so much for joining us this morning. We appreciate it. Let's dig into this. At the center of this decision is the Mississippi abortion law. Explain to our viewers, as a refresher course, what's in it and why is this case so consequential?
The Mississippi law prohibited abortion after 15 weeks of pregnancy, which in effect was several weeks before viability. And the court basically has upheld that Mississippi law as having a rational basis. And so under this new opinion that's been leaked, which of course is not really a final opinion, it gives us Mississippi law as an example of the type of law that would survive judicial review once you return the issue to the states and say there's no fundamental right to abortion.
So if this briefing was to stand, if this is the opinion of the land, as you point out, it means that the decision and choices goes back to the states, right? So then what are the legal implications? How would things change?
Well, right now, the current law under Roe and Casey is that because there is a constitutionally protected liberty of women to decide about terminating their pregnancies, the states cannot adopt a law that imposes an undue burden on their ability to exercise their choice. And so the test has been since 1992 with Casey, is this an undue burden? This draft opinion says that test is arbitrary, it's impossible, the viability line is impossible. So whereas before women prior to viability should be allowed to make the ultimate decision, this new opinion basically abandons that and says it's totally left to the states. And as long as they have one of several legitimate interests, including some new ones that have not previously been recognized by the court, like not discriminating based on race, sex, or disability, or not feeling fetal pain, then the states may regulate or prohibit abortion.
So, Linda, I've seen some conservatives pointing out a reference to the 10th Amendment to the Constitution. The power is not delegated to the United States by the Constitution, nor prohibited, but to the states are reserved to the states respectively or to the people. But that 10th Amendment, just describe for our viewers how it's been traditionally interpreted over the course of the history of this republic, specifically as it regards to the issues of enslaved people and what it could mean perhaps for the future. This notion of states' rights, which is what a lot of people are signaling here, that these decisions should be returned to the states, that is proven in some instances, not all, obviously, because we do have a republic that guarantees that liberty of the states. But I just want to get your sense of that amendment and why people are thinking it applies here, but how it could also be detrimental to some people in this country as well.
Sure. Well, interestingly, the majority of this draft leaked opinion doesn't really talk so much about the 10th Amendment. It's just that if the Constitution doesn't say something, and if there's not, if it doesn't if it doesn't fit within this notion of unenumerated rights under due process liberty, then it's left to the people. And so then the 10th Amendment basically says any right, that anything's not explicitly restricted by the federal government are left to the states. Now, in this case, I think it's important to note that this draft opinion claims that overruling Roe and Casey will not affect other due process liberty cases, including the Obergefell right to marry case, because many states argued that the right to marry should be left to the states to regulate under things like the 10th Amendment. But this is a draft, and this is probably to get Kavanaugh's vote, and it may drop out. But right now they claim that this opinion will not affect a whole series of other important due process liberties, including the right to contraception. But if you really take seriously their claim that what's unique about abortion is it destroys potential life, there are many conservatives who think forms of contraception destroy potential life. So it's not clear what this part of the opinion really is going to mean.
Yeah, and I think we're going to keep having this conversation sort of throughout the day, because I think what you're suggesting, and you're the expert, I'm not, that, we talk about Roe v. Wade, but the other sort of big court case is Griswold versus Connecticut, and it has to do with privacy rights that are not spelled out in the Constitution, but they're certainly inferred. And that is the possible spillover effect. If, we're talking about same-sex marriage, we're talking about other issues that are associated with privacy rights. So Linda McClain, I could talk to you forever on this, but we got to let you go. Thank you so much for your expertise.
Thank you. Okay.